Okay, great. So the sponsor of this panel is Leif Cabraser, Hyman, and Bernstein. That's wonderful. We're very grateful to them for doing that. We have 4 excellent speakers, and so I don't want to spend too much time introducing them, but I'll say a few words about each of them, and I just want to tell you that I'm not going to do their wonderful resumes justice in the amount of time that I'll spend on them. I'll also say my name is Lisa Heinzerling. I am, in my permanent life, a law professor at Georgetown University Law Center. I've been there since 1993, but since the day after inauguration in 2009, I've been at the Environmental Protection Agency, where I'm now the Associate Administrator of the Office of Policy. We're going to have each of the speakers offer a somewhat different perspective on the topic in front of us today. They'll take about 9 minutes apiece to speak. After that, we'll have a discussion among us, moderated by me. And then after that, we'll have time for questions from you and answers, we hope, from us. So that's about the way it'll unfold: opening statements, moderated discussion, and then questions and answers. And we're going to start with Vicki Arroyo, who is the Executive Director of the Georgetown Climate Center at the Georgetown Law Center, who I am always somewhat guilty upon seeing because I hired her immediately before taking the job at EPA. So I hired her, said hello, and then said, and I'll see you later. But she's wonderful. She works at the nexus of federal and state climate initiatives, and as does the center. She has done work in mitigation as well as adaptation. Before going to Georgetown, she was at the Pew Center on Global Climate Change, where she was a vice president for domestic policy. She has been in private practice. She's worked for the EPA. She has worked for the Louisiana Department of Environmental Quality. And so that she has really seen the environmental issue and also the climate change issue from a whole variety of perspectives. Today, she's going to be talking specifically about this nexus between federal and state initiatives. We're also lucky enough to have with us this afternoon Rachel Jacobson, who is the Principal Deputy Solicitor of the U.S. Department of the Interior. Busy days for the Department of the Interior, so we're particularly grateful for Rachel taking out her time this afternoon to be with us. The Solicitor's Office works on all legal matters within the authority of the Department of the Interior, and including issues relating to climate change in federal resource management. Before going to the Department of the Interior, Rachel was the director of the Impact-Directed Environmental Accounts at the National Fish and Wildlife Foundation. She was also, prior to that, a senior trial attorney and a supervisor at the United States Department of Justice. Andrew Light, moving down further along the panel, is a senior fellow at the Center for American Progress. He specializes in climate, energy, and science policy, and particularly international climate change policy, and so that'll be a focus of his remarks today. He's the director of the Center for Global Ethics at George Mason University. He is the author, co-author, or editor of an impressive 17 books, and is a recognized expert on the relationship between environmental policy and ethics, and on the ethical and social impacts of new and emerging technologies. Finally, but not least, is Jonathan Adler, who is a professor of law at Case Western Reserve. He's the director there of the Center for Business Law and Regulation. He is the author or editor of 4 books on environmental policy, plus many, many articles on that subject. He is also the 2004 recipient of the Paul M. Bator Award from the Federalist Society for Law and Policy Studies. That award goes to an academic under 40 for excellence in teaching, scholarship, and commitment to students. So you can see we have an excellent panel, extremely well-credentialed, variety of perspectives, and so we're going to hear from each of them and then, again, have a discussion among ourselves. So thank you for coming, and I look forward to the discussion.
Thanks, Lisa. And as hard as it was to give Lisa up, we all really need her and all the other great people at EPA, so we really should thank her for her service there. As you all may know, if you've followed the climate change issue, for many years we really have not had a comprehensive federal climate policy in the form of legislation. And of course, until this administration, we had an administration for many years that did not even use the existing authority that it has under the Clean Air Act. And so stepping into that breach have been the states, the U.S. states, not all of them, but a large number of states who have done everything from climate action plans about identifying the actions that they can take to reduce their greenhouse gases. 36 states have done or are doing climate action plans. 29 states plus the District of Columbia have renewable portfolio standards on the books that say that a certain percentage of their energy should come from renewables. And they might be doing that for reasons other than climate change, also for, just sort of pushing renewables and creating clean energy jobs, if you will. But then there are states that have really taken on greenhouse gas emissions targets with the objective of reducing their contribution to climate change. So 21 states with greenhouse gas emission targets, and that includes California's enforceable AB 32, which is legislated a target that can be met by a whole variety of approaches, including the California vehicle standards, the PAVLI standards from 2001 that have then been adopted by over a dozen states, and then now, as you know, because of the Obama administration, become the federal law of the land as well. Renewables and low carbon fuel standards are being adopted at the state and regional levels. And they're even operating cap and trade programs. You're probably familiar with the RGGI program, which is the Regional Greenhouse Gas Initiative. If you're not, it's a cap and trade program like we have with acid rain pollution under the Clean Air Act, but it is with CO2, so it's a greenhouse gas program for utilities in the Northeast and Mid-Atlantic states. That's already generating something like $600 million worth of allowance value from the auction of allowances in that program that is being reinvested in states at a time when, frankly, states really need the money. And so that's looking pretty good to them, and they are investing that in efficiency and renewables and all kinds of other good things in their states. Other regions of the country have states that have joined forces that are in the process of developing similar approaches. Western Climate Initiative has a broader regional greenhouse gas program that they're developing but isn't underway yet like RGGI is. And the Midwest states joined together, and some of these, like WCI, the Western Climate Initiative, and Midwestern Accord also join with Canadian partners and are developing a program there as well, although the Midwest is a little bit further behind, and right now, given that we're hoping we might see some federal legislation, I think mostly the recommendations have been turned to trying to inform the federal dialogue. This week, my center, the Georgetown Climate Center, our center, in cooperation with a number of the RGGI states, plus Pennsylvania, plus the District of Columbia, just announced this really exciting initiative in Delaware with the transportation commissioners joining their energy and environment counterparts. So we had roughly 33 folks around a large table, and I facilitated a discussion, and we came out of that event with an initiative, an agenda for progress, where the states in the Mid-Atlantic and New England states would work together to reduce greenhouse gas emissions from transportation from all legs of the stool. I mean, even things like land use, which some transportation agencies have not necessarily wanted to talk about as much as getting emissions from vehicles and cars, emission reductions from vehicles and cars. Now that's on the table, and they're doing some really exciting things within some of these states, but now they want to work together across the region as well. And so, of course, at the same time, you see EPA now moving forward using its existing authority under the Clean Air Act as required by Mass versus EPA. But we still have congressional action stalled. And, of course, we're all waiting to see whether or not the oil spill changes that dynamic. And, in fact, bills to reduce greenhouse gas emissions have been introduced for many, many years now, almost all with bipartisan support, but we still don't have enacted legislation. We've gotten closer than ever in this Congress. We did get a bill. We saw a bill go through the House, the Waxman-Markey bill, ACES. That was a cap and trade bill plus a lot of other energy kinds of items, including efficiency standards. That passed last June. The Senate Environment and Public Works Committee saw Kerry Boxer, a similar bill passed, but more along party lines, unfortunately. And then you saw the trio of Kerry, Lieberman, and Graham trying to negotiate something outside of the committee process to see if they could get closer to 60. You probably know that Senator Graham dropped off of that bill, but the American Power Act was released last month as a Kerry Lieberman bill. This bill combines cap and trade of large sources like the previous bills with a refined fuels fee, if you will, including transportation fuels. Support for nukes are in the very first section of the bill. That was a little surprising when I saw the first, for the first time, that 1,000-page bill. Oil and gas drilling, obviously, has been an important part of the story in the development of this bill. This bill had started just as the bill was being rolled out, so they pulled it back and made some minor changes, but I think this would have to be more major changes now. There was some ability of the states to constrain some of the new drilling, but it would require the legislature and the governor to sign off on that. There was some revenue sharing for the OCS revenues that were coming in from the additional leasing. There's investment in carbon capture and storage from coal, in renewables, in electric vehicles. There is a pretty broad program on transport and trying to get national goals to reduce emissions from transportation and to incentivize through some of the allocation states and MPOs to do transportation planning to reduce the emissions from the roughly third that comes from transportation in this country. And on that planning section for transportation and a number of other sections, you actually see the federal bill building on what the states have done, because many states, as I said, the majority of states have done climate action plans. But otherwise, the bill is a very federal approach. It preempts the existing cap and trade programs permanently, including RGGI, which is up and running and already generating, like I said, a lot of revenue. And this is a change from some of the earlier bills, from McCain-Lieberman and from Lieberman-Warner, where, like most other environmental statutes, they consider the federal bill a floor, and the states can go beyond that. That changed earlier this session with the Waxman-Markey bill and the Kerry-Boxer bill, preempting for a certain amount of time the state cap and trade programs while the federal program got up and running from 2012 to 2017. But the states were there as a backstop. If for some reason you saw, litigation hold things up, or a future administration not actually, moving forward with the program, the states could step back in. That is not the case in the language that's on the table with the Kerry-Lieberman proposal. It does have some savings provisions that retain state authority to do a number of other things, including adopting and enforcing standards that aren't met by a cap and trade program. It retains the California CAR program and encourages, as we saw with this round, where the states worked with EPA and DOT and the auto industry to craft a deal. It encourages that to happen again. It allows for states to have fuel standards, and even to require allowances to demonstrate compliance with other state policies and standards. And they get some modest allocation, although not as much as they're getting right now for the RGGI states. And the people who are holding state allowances under RGGI are made whole. But there are some concerns about maybe arguments about obstacle preemption or conflict preemption being read in where there is some limited preemption, and there is some examples where that has been the case. And for example, in previous energy bills, there have been product standards at the federal level, and they did want the states, state by state, to develop product standards. And as a result, a federal district court in Albuquerque said that a building code that was very aggressive about efficiency was preempted by federal law, even though the energy bill really had a savings clause. And there are other examples of this. When New York tried to go further with controlling SO2, sulfur dioxide pollution, they were told that they were conflicting with the intent and the ideas behind the acid rain trading program and the Clean Air Act. And so there is some concern that any preemption language might be a concern. There's also some confusion right now about the language that allows, that does not allow EPA to use some of its traditional Clean Air Act authorities post-bill. And some of the states are actually told in their legislation that they can't go beyond the EPA minimums or federal minimums. And so we need to sort of sort out what that means for the federal-state interaction, because there are limitations on the EPA as well. I'll just say, because I think I'm approaching the end of my time, the states and those who work closely with them certainly want a federal bill. We need it also for the international negotiations that Andrew will tell you about. But it would be unfortunate if a federal bill would preempt either directly or indirectly some of these activities that are going on. Climate change is a pervasive problem. We all contribute to it through our activities, and greenhouse gases are pervasive. And so we'd like to see proposals that really encourage states and locals and us all to continue to do our job in the future. Thanks.
Thank you. Okay, thank you very much. I'm going to talk about the federal land manager's role in addressing climate change on the ground. And first of all, I'm very glad to be here today. It is, I can't tell you what a refreshing break this is from oil spill, which is not only dominating your nightly news, but is also dominating our every minute of every day. So it's also a sign of hopefulness to talk about planning for going forward rather than crisis management. Not to say that climate change is not a crisis, because it is, but we have to be very thorough about our planning for adaptive management on public and private lands in order to address the on-the-ground effects. The level of planning and assessment going on among land managers in the federal government cannot be overstated. But we're finding that these issues don't necessarily lend themselves to traditional regulatory models and require new governance structures incorporating collaborative approaches among all land and resource managers if we are to succeed. As you may or may not know, the Department of Interior manages more than 500 million acres of land, which is about 2/3 of the land owned by the federal government, and 20% of the total land mass of the United States, not to mention the 1.7 billion acres that we manage in the Outer Continental Shelf. These lands include everything from national parks, wildlife refuges, pristine wilderness areas, to public lands that are leased for grazing, mining, and oil and gas exploration. We also manage 50 million acres as trustee for American Indians, and we supply drinking water and irrigation to over 30 million Americans. So our stake in climate change is huge. These are the resources we manage on behalf of the American public. The stake is absolutely huge. We're not a major emitter, and nor do we regulate tailpipe emissions, which falls under EPA's domain. But we're responsible for most of the energy resources on public lands, and at the same time, of course, we're responsible for managing natural and cultural resources that will be most severely affected by effects of climate. So what are we doing to address it on the ground? Last September, Secretary Salazar signed an order entitled Addressing the Impacts of Climate Change on America's Water, Land, and Other Natural and Cultural Resources. And that order established a Climate Change Response Council, which is chaired by the Secretary and coordinates activities to develop and implement strategies for climate change response. And we're working at the national, regional, and landscape levels to identify a set of goals by 2012. Our goal is to identify by 2012 the areas and species in the U.S. that are most vulnerable to climate change and to begin comprehensive adaptation strategies in these areas. So it's a pretty ambitious goal, and we've gotten pretty derailed by the spill. But we want to be able to reach that goal because it's vitally important. Our response to climate change we can say falls roughly into three primary areas of responsibility: scientific resource management, natural and cultural resource management, and energy resource management. I'll talk first about our role as a scientific resource manager. We house within the Department of the Interior the U.S. Geological Survey, which is one of the federal government's premier science agencies with significant expertise in earth, marine, atmospheric, and ecological science. And they are a focal point in understanding globally forecasting and understanding globally what is happening to the climate. And the USGS currently operates a National Climate Change and Wildlife Center, which has already been up and running. But in accordance with the Secretary's order to establish the Climate Change Council, we're expanding the climate change science expertise by opening 8 regional climate science centers, so that'll cover the entire United States. And those climate centers will work together with other science agencies to provide forecasting tools to link physical factors with biological, hydrological, ecological, and cultural resource response variables. So it'll essentially develop important forecasting and modeling tools. Because as the first step, you want to know what's happening and what's going to happen and how quickly. And the climate centers will also develop some response models and projections for degradation of priority ecosystems, species, and habitats. Of course, to be most effective, the application of these forecasting models must obviously be reflected on the ground. So we have to bridge the gap between the global scale modeling and site-specific implementation of adaptation strategies and management practices. So that brings us to Interior's role as the nation's foremost manager of natural and cultural resources. Because the effects of climate change obviously cross jurisdictional boundaries. We can't just focus on improving our own management practices within the federal government. We have to have collaborative efforts that will tackle landscape-level problems. And so as a part of this, to be part of this solution, Interior is creating landscape conservation cooperatives, which will be partnerships among federal, state, tribal, local governments, NGOs, any entities that manage large segments of land. And the members of these landscape conservation cooperatives will be these land, water, wildlife, and cultural resource managers. So they'll be professional resource managers, and they will function as the link between the global science and the on-the-ground conservation. They will focus on impacts such as sea level changes, wildlife migration patterns, wildfire risk, drought, invasive species, the kinds of effects that typically extend beyond the boundaries of any single National Wildlife Refuge, BLM unit, or national park. And the climate science centers will provide the essential data and science to the landscape conservation cooperatives within their regions. So there's a real focus to bring in state action plans for climate and so forth by looking at it at a real regional level, because obviously this is the way it's going to have to work. We can't dictate from Washington how the northern coast of Maine is going to respond compared to the Hawaii. I mean, it has to be based on a regional level, incorporating what states and others are doing. Also, but to effectively address climate change, traditional assessment and resource management tools may no longer work. Take the Gulf as the primary example. The natural resources that were injured, that continue to be injured, that will continue to be injured by this horrific spill, were already impaired by the effects of a change in climate. And these will make those effects and that impaired state will make these resources less resilient and will increase the time for those resources to achieve full recovery. Resource managers at every level will grapple with these challenging issues as we embark on the largest comprehensive restoration effort in the history of our nation. From a liability standpoint, I say to those who are responsible, beware of the climate-impaired resource. It's the Gulf's version of the eggshell plaintiff. Finally, we come to Interior's role as an energy resource manager. As many of you probably know, Interior plays a central role in the nation's energy production, both carbon-based and renewable, primarily as trustee for citizens of the nation. We lease out public lands for oil and gas production And as you're all now aware, we also lease out parcels in the Outer Continental Shelf for oil and gas development. These leases generate tens of billions of dollars annually on behalf of the American taxpayer, second only to the IRS. So that's a piece of what's at stake here, just to put a point on that. But at Interior, we're also very focused on renewable energy. Last March, Secretary Salazar signed an order which made development of renewable energy on public lands a top priority. And we're working hard to develop solar, wind, and the geothermal projects. In the Solicitor's Office, we've created the Renewable Energy Practice Group to counsel our clients on such issues as how wind projects can comply with the Bald and Golden Eagle Protection Act. And most of you have probably heard the recent announcement about the creation of the Atlantic Offshore Wind Energy Consortium, which includes all of the affected states, and the approval of the Cape Wind project off the coast of Massachusetts, which we're pretty certain will be in the courts for years. Last September, Secretary Salazar also established the Interior Carbon Storage Project, which will explore the use of public lands for both geological and biological carbon sequestration. Along with this role comes responsibility for making sure that public resources are used safely and responsibly, and making sure that we take into effect climate change impact at every single step of the way. I've given you a quick overview of what our climate change problem looks like as a manager of scientific, natural, and energy resources. And I've tried to highlight some of the inherent tensions in our roles, such as between our responsibility to develop the nation's energy resources and our responsibility to protect natural resources, including from climate-driven threats. Between our mandate to quickly develop clean, renewable resources and our desire to avoid the same problems that have plagued conventional energy development. Between the need to evaluate the environmental consequences of our action, including effects from climate, and the difficulty of measuring the downstream indirect effects of those actions. I'd like to conclude my talk by asking you in the audience to think about some hard questions, not necessarily to respond during this session, but just to think about. How should our statutory role as primary manager of public energy resources fit with our statutory environmental responsibilities? What role should the courts play in resolving these conflicts? How can courts balance the need to keep us true to our statutory mission for energy development with the need to leave room for political branches to develop creative, comprehensive policy solutions? What role should NEPA, which was primarily designed to evaluate impacts of acute regionalized environmental harms, play in grappling with the diffuse global scale threat of climate change? As I said, we're probably not going to have the opportunity in this short session to answer these questions, but as ACS members, it's really up to you to inform creative policy making and to generate the will to keep these debates ongoing, and we want to get to the right solutions, so we look to you for help on that. Thank you.
Thank you very much.
So I want to start just speaking for myself by apologizing to the head of British Petroleum. Thank you. I thought we needed a little levity. So my job is to not to apologize to the head of British Petroleum, but instead to talk about the international dimensions of the climate process and also where the U.S. fits into that. I'm going to be brief, and I'm going to give a kind of a very general overview of the process. So if this is like me, you work in this kind of stuff every day, we can get into more of the details and nitty-gritty in the discussion. Essentially, the UN climate negotiations have been going on since 1992 when there was the Earth Summit in Brazil. We'll be heading up to the 20-year anniversary of that meeting pretty soon. And since then, we've had 15 big climate summits. The last one, most of you will know, was the very big one, a very signature one, which was in Copenhagen last December. Essentially, there have been two big agreements that have come out of this process. First was just the creation of the process itself, which is an international treaty creating the United Nations Framework Convention on Climate Change, which the United States did sign. And the second, of course, is the Kyoto Protocol, which was the first international treaty that established binding emissions cuts for signatory parties, which the U.S. did not sign. Now, the reason the U.S. didn't sign the Kyoto Protocol is pretty much summed up in the 1997 Byrd-Hagel Amendment that passed the U.S. Senate. It was a 95-0 vote, basically with the Senate sort of sending a message to the Clinton administration saying, don't even bother to send us the Kyoto Protocol to read, because we're not even going to consider any kind of agreement which doesn't require the other major emitters in the developing world, especially China and India, to try to achieve some kind of reductions in emissions which are similar to what you're going to require developed countries to do. So the way the Kyoto Protocol is set up, you've got developed countries and developing countries in these two different buckets. And in the first iteration period of the Kyoto Protocol that expires in 2012, the developed country parties have to agree to a certain quantitative emissions cuts below the accepted baseline of 1990, and then developing countries kind of get a pass in the interim. Now, the physics of the matter, of course, can't tolerate that kind of solution forever. If all of the developed countries of the world, including the U.S., were to turn off the taps today, and China was to go on what had been their business as usual pathway, although they have certainly done a lot, in fact, more than we have in terms of national emissions reductions since then. But if they were to continue on a business as usual pathway, then we would continue to accumulate concentrations in the atmosphere of CO2 which were unacceptable. And in terms of what we think is acceptable or not, basically the main body of scientists who have released the 4 big reports on climate science and mitigation, the Intergovernmental Panel on Climate Change says that basically what we want to do is hold anthropogenic temperature increases to 2 degrees C over pre-industrial levels by the end of the century. So that's kind of where we're going. The U.S. didn't sign Kyoto, and it said, we were not going to sign any kind of agreement until developing countries agree to some kind of cut themselves. And along the way, essentially, the deal that was struck was that developing countries would agree to some kind of emissions cuts if we were to help to provide, if we provided some financing, which would make it possible for them to begin to bend the curve downward on their carbon emissions. And that's kind of where we are. Since 2007, there have been two really important tracks in the negotiations and a bunch of sort of smaller tracks in negotiations. The 2 most important ones are a track on the future of the Kyoto Protocol, whether it will be extended into a second commitment period after 2012 and take deeper cuts and maybe add more parties to it. And then an alternative track called the Ad Hoc Working Group on Long-Term Cooperative Action, which is looking at the possible creation of a second treaty for those who don't like the Kyoto Protocol like us, and for those who are not bound to make reductions under the auspices of the Kyoto Protocol, such as China, India, Indonesia, Brazil, the other major emitters in the developing world, which we need cooperation on. There are smaller tracks that are very important on technology cooperation, on how you monitor reductions in carbon emissions, how governance, on forestry, which is probably one of the most important parts of this whole deal because it's the cheapest and most effective ways of getting carbon reductions, is avoiding future deforestation and doing some reforestation, and things are moving ahead. Now, after a pretty disastrous summer of negotiations, we have these big meetings every year, and then we have at least 2 smaller meetings, if 2 or more smaller meetings that happen in between the bigger meetings where they try to make progress on negotiating text. After a pretty disastrous summer, and I can talk about why that was the case later, we went to Copenhagen and did not produce what was hoped to be the goal there, which was a brand new treaty that either an agreement to extend the Kyoto Protocol, and this is what it's going to look like, and more countries will join in, or a new treaty to replace it, or something else. Instead, we produced something that I think is in fact a surprising success. We produced a document called the Copenhagen Accord, which is a non-binding but politically substantial agreement where the parties aligning themselves to the Copenhagen Accord agree to this goal of holding temperature increase to 2 degrees C. There aren't any emissions targets in it as such yet, but requires parties that do sign on to come up with national plans for how they're going to meet their commitments to get on the pathway there by 2020. By midnight on January 31st, which was the deadline for aligning yourself with the Copenhagen Accord, over 120 countries had signed on to it. And if you take the collective commitments of all those countries, and we can talk about some of the, why I'm going to, some of the numbers behind this and why I think they're useful later. essentially, I think that if everyone did what they say they're going to do under the Copenhagen Accord, which does include the major emitters like China and India, Brazil, et cetera, then we would be 2/3 the way of where we need to be by 2050 to achieve this climate safety mark. So that's very good news, because it gives you something, sort of a target which you can work for. The challenge then becomes locking in those commitments, making sure people do them, and then secondly, squeezing the rest of the gigatons of carbon out of the atmosphere, getting additional commitments to do that. Now, how do we move forward, and how do we get sort of some traction in going forward? Like I said, the Copenhagen Accord is not yet a binding commitment. It's a political agreement. It gives us sort of room to breathe and keep going as we move forward. Basically, what the rest of the world is looking to the United States to do is deliver on two things. Number one, we have to deliver on what we promised to do under the Copenhagen Accord. And what the U.S. surprisingly promised to do after a summer of refusing to actually put a number on the table of what our reductions were going to be by 2020, which is sort of the accepted midterm target point. They took the number out of the Waxman-Markey bill that Vicki had talked about earlier, which is a 17% cut below 2005 levels by 2020. Well below what other developed countries are doing, but nonetheless acceptable to most, because we can demonstrate a fairly convincing path of how to get there to where we need to be by 2050. The second thing that the world is waiting to see is if the U.S. can deliver on our promise for money that can actually contribute to this fund that's going to help developing countries to get there. We promised before Copenhagen to contribute to a $30 billion quick start financing package between 2010 and 2013, and we are delivering on those commitments as we speak now. They're mostly coming from U.S. appropriations. But we also agreed that by 2020, the aspiration should be $100 billion annually of funds in order to make it possible for developing countries to continue. Now, the question that we then look at, the way that I sort of analyze the different pieces of legislation that we're looking at is number one, do they deliver on the 17% cut? And secondly, do they provide a mechanism for financing? The Senate bills that have been floated so far would, if reconciled appropriately with the House, would get us the 17%. The House bill would have provided a mechanism through cap and trade to deliver on the financing that's needed. The Senate bills in their current stage do not. And so the question is, as we move forward, are we going to be able to put together a climate package which is going to be able to deliver on those things? If we have no Senate bill whatsoever, then I think at least we should be able to deliver on the 17% commitment, taking state action, which right now, if you combine with everything the states are doing, that's about 7% cuts below 2005 by 2020, and EPA regulation. But then the trick is going to be whether or not we can get a financing package that works forward. Now, if we have time in question and answer, I'll talk about some other options for moving forward. Most of what we're doing at the Center for American Progress now, as we wait for these negotiations to sort of move along, is to look at other opportunities for multilateral and bilateral negotiations with a smaller groups of parties that are negotiating in the UN, which might actually be able to get the financing and get the reduction commitments that we need on the international level. And on that score, I think actually we're quite hopeful that something can be done. Thanks.
Okay, well, thank you for the invitation to be here. It's certainly a pleasure to be back at the American Constitution Society. I think my role in some respects is to be the designated naysayer on the panel. And I guess I appreciate the opportunity to take that role, hold your tomatoes and the like till the end, I guess. What I'd like to do just initially is, or what I want to very briefly do is outline some notes of caution about what we're doing and how we're going about it. And first, I want to say a little bit about some of the legal issues, which I think complicate a lot of the things that we're talking about. And then I want to say a little bit about the big picture in climate change policy and why I think that a lot of our focus on certain types of intermediate agreements, regulations, and various programs is really a misplaced emphasis and actually threatens to divert our attention from the only things that have any chance of achieving the ultimate goal of stabilizing atmospheric concentrations of greenhouse gases, which is I'll come back to is really the only goal that matters if our aim is to prevent significant climate change. In terms of legal issues, there's a lot here. We could spend multiple panels on some of the legal issues that are out there. There are a lot of remaining questions about the scope of both federal and state authority and their interrelation in the climate context. litigation, lots of litigation ongoing challenging various federal initiatives, ranging from litigation challenging the EPA's initial endangerment finding, several nuisance cases which are in various stages of litigation in federal courts, some of which look like potential cert grants, litigation over the application of the Endangered Species Act to climate change and how climate change and the Endangered Species Act interact, litigation over the preemptive effect of existing laws, existing federal laws, and how that affects state action. And, barring legislation relating to these issues, and I think legislation, at least this calendar year, that directly addresses these issues is unlikely. Energy legislation maybe, but not climate legislation. These issues are going to be fought out in the courts, and I don't think are going to be resolved in the near term. One set of legal issues which I think is particularly interesting and particularly important and worth watching is legal issues that are arising under EPA's efforts to essentially fulfill the mandate of Massachusetts versus EPA and treat greenhouse gases as pollutants under the Clean Air Act. The EPA has made an endangerment finding. I don't think that was a particularly remarkable move in the sense that I think it was not only expected, but I think entirely legally defensible, if not legally required. But some of the things that sets in motion within the Clean Air Act present some very interesting questions. And the one that I'll just outline very briefly is what does this do to regulation of stationary source emissions? And the reason this is a particularly interesting question is because there are certain portions of the Act that require emissions of any pollutant that's regulated under the Act to be accounted for in permitting and technology standard provisions. And these provisions of the Act have statutory thresholds that trigger their application. And for those of you that are very familiar with environmental law, these are provisions in what's called PSD, or Prevention of Significant Deterioration, and Title V. And traditionally, in the statute, the thresholds are 100 or 250 tons per year emission potential, or potential to emit that much. And that made sense for the sorts of emissions that the Clean Air Act was written to address. What's interesting is that when one looks at emissions of greenhouse gases, and in particular carbon dioxide, one realizes that we're not talking about several hundred or even a few thousand facilities that cross those statutory thresholds, but hundreds of thousands, if not over 1 million. EPA's initial estimate was applying these thresholds to greenhouse gases increases the universe of regulated facilities 140-fold. That's remarkable in terms of what EPA and state agencies have to do in terms of processing permits. And so the way EPA has responded to this is to say that it's not feasible and that the doctrines of absurd results and administrative necessity require it to essentially rewrite the numerical thresholds in the statute by adding several zeros and essentially rewriting them and it's phased in, so it's more complicated than this, but essentially rewriting the threshold of 100 or 250 tons per year to 50,000 tons per year. I think that as a legal matter, that's a highly questionable move. I think it rivals some of the, shall we say, creative statutory interpretations the Bush administration offered of the Clean Air Act, the vast majority of which were summarily rejected by the D.C. Circuit and even prompted a fairly pointed speech by Judge Tatel at the Environmental Law Institute last year about the need to take statutes more seriously. And I think it highlights some of the difficulty of taking regulatory architecture that was designed decades ago for one set of problems and applying it to something like climate change. And for good or ill, the Supreme Court has said that is what we are to do. I was one of those who argued that the Supreme Court should not interpret the Clean Air Act that way. At least it was one of those who argued far more successfully that we should apply the Clean Air Act that way, but this is one of the consequences of that. Now, in terms of the big picture, in terms of thinking about climate change, one of the things we have to keep in mind, as I already mentioned, and as Andrew noted, is that the whole ball game is global atmospheric concentrations. Emissions here, emissions in China, emissions in India, Brazil, Germany, wherever else, doesn't matter. What matters is the aggregate level of emissions and how that affects atmospheric concentrations. In fact, whether or not we even focus on emissions, depending on the state of technology, might not even be important if there are ways to suck carbon out of the air, and that's certainly something some people think we will be able to do at some point. And that's kind of sobering to think about, that atmospheric concentrations are the issue, because all the things we're talking about, even the 17% goal, really don't get us on much of a glide path towards addressing that, even if we believe those numbers are real. And so, for example, I'm one that believes that Waxman-Markey, the House bill, is so riddled with loopholes and giveaways to various economic interest groups that the emission reductions it claims are a facade, and that if it were adopted, there's no way we would actually get the reductions it talks about. Among other things, the agricultural offset provisions were written basically to placate the agricultural lobby, and as a consequence, aren't going to provide verifiable emission reductions. And it's also important because the sorts of reductions we're talking about doing are quite dramatic. The ultimate goal the administration endorsed was 80% emission reductions by 2050. National Academy of Sciences said that ballpark of emission reductions, or even slightly less than that, could be met if we were very ambitious and we make very, very optimistic assumptions about technological innovation and diffusion and adoption and reliability. Our experience in these areas suggests there are reasons to be skeptical of that. Just so you all know what 80% reductions by 2050 means, that's aggregate U.S. emissions about what they were in 1910, but we'll have over 4 times the population. So per capita emissions, as best we can tell, we're talking about per capita emissions around what they were in 1875, which is per capita emissions of, say, Grenada, Botswana, less than half of the per capita emissions of countries like Switzerland and France, countries that rely a lot more on respectively hydropower and nuclear power than we do now, and that we are likely to in the future. And also don't have the vast expanses that we have geographically that complicate our efforts to reduce energy intensity. So it's a monumental task. I see that I'm rapidly exceeding my time, so let me just make one last comment. I think the key to atmospheric stabilization, and this is especially true on the international level, is technological innovation. The reason I say that is because if we don't dramatically reduce the cost of decarbonizing industrial society, nothing else we do matters for atmospheric stabilization, because China is not going to sign an agreement that is costly to it and prevents it from developing economically. India is not going to do it. Brazil is not going to do it. So if we can't make it cheap for them to decarbonize, as well as make it cheap for ourselves, we're not going to do it. In fact, I don't even believe Europe's going to do it. In 2008, Germany permitted 20 new coal-fired power plants. Does that sound like they're really aggressive in terms of reducing their carbon emissions? And the way we reduce the cost of decarbonizing our economy, unfortunately, is not through our traditional regulatory and subsidy tools, but through a more innovation-oriented agenda, something that we haven't been doing. And that involves, I think, a combination of price and carbon, but I think there are much simpler ways of doing it than the sorts of legislative proposals that are talked about, supporting actual innovation, as well as removing barriers to innovation. And certainly in Q&A we can talk more about that, but I've already gone over, so I will stop there. Thank you.
Thank you. So I just want to make an observation and then ask the panelists if they wanted to comment, and then after that we'll open it up for questions from you all, because obviously we want to get to that as soon as we can. But one of the things that I've observed in debates over climate and reactions to climate before, and I can see in this panel discussion today, is there's two things that seem to happen and that feel kind of in tension with each other, but maybe they're not, which is that on the one hand, we have a great deal of activity already happening. We have the activity at the state and local level that Vicki mentioned. We have the activity in the federal agencies recognizing that climate change is upon us, that Rachel discussed. We have a lot of international activity, as Andrew talked about, regulatory activity, activity in the courts, as Jonathan mentioned. So there's this sense of a great deal of motion and discussion and change. Yet at the same time, it always feels like we're waiting and waiting for something really big to happen. Of course, we've got all this stuff happening, but we're also just sitting there, well, we'll wait. We'll wait for the EPA to say the next word. We'll wait for federal legislation to come in and take over the states' roles, because they've kind of hoped for that to happen. We'll wait for the international agreement. And so I guess I just offer the possibility of, one, remarking on that dynamic, if you want, and then two, thinking about what you'd expect if we gather again in a year. What do you think we'll have maybe stopped waiting for, or what situation might we be in, either from your perspective, if you wish to state what you'd like or what you'd predict might happen. So there is this sense in which we're always acting, but we're always waiting for the next big event to happen.
Well, I guess I'll start. In spite of the activity of the states, it's, obviously been a state-by-state call, and we didn't want to use PowerPoints in this setting, but they're really pretty effective when you're talking about state action because you can see the places that are really active, and they tend to be the coast. And, where I'm from, the Delta states are not very active in terms of the kind of policies to reduce greenhouse gas emissions, and yet, obviously Texas, Louisiana, these are big states that have a lot of energy use, a lot of fossil fuel production, and so, we can't get there from here, even if individual state efforts or individual firms who have made commitments, and there have been many who on a per firm basis have really reduced their contributions in line with or exceeding the Kyoto kind of targets with their own carbon footprint. But it's just not enough without us all being under the cap, which is, my personal affinity for a cap and trade program, whatever you want to call it. And right now, I think there's a movement in the political sphere to not call it that for whatever reason. But the cap is important, and it does give you that kind of integrity. And so, what I would like to see, ideally, is, more movement on that kind of federal bill. And, I'm heartened by the fact that, right before Waxman-Markey, I don't think people really thought that it was possible necessarily to see a bill that comprehensive get through the House. And so, hopefully that can happen again in time before this Congress ends. But if not, we'll try again next time.
I think we have to engage in active waiting. This is going to take a lot of different efforts on different levels, both from the emissions side of the House and from the increase in renewable energy side of the House. So while we're waiting, we must increase our efforts to encourage development of renewable energy. We must look at carbon sequestration, both geological and biological. We must learn to reduce our own personal habits, and the oil spill, I think, should be a reminder of that. We must plan for adaptation on the ground to minimize the effects. So there's all these things that are going on are very hopeful again, because it means we're engaged in active waiting. We know that there are big decisions that have to be made by Congress and others, but in the meantime, federal agencies, state agencies, local governments, tribes can take very concrete actions, at least here, to address some of the problems. So we're doing that. Active waiting, I think, is the way I would address it.
I think that this time next year, we will have some kind of legislation through Congress. I think that the oil spill effectively makes it impossible to finish this term without at least an energy bill and an oil bill. I don't know if we'll get a cap on carbon like the House bill. I don't know if we'll get a cap and trade system or any other way of pricing carbon out of it. And I think there are more effective ways of doing it than the House bill did. The administration's plan that we know as of Wednesday is to get something done, to get something voted on in the Senate by the August 4th recess, and then do a long reconciliation period that lasts through the midterms, so that members aren't forced to vote, have another controversial vote before the election, and then try to pass this through lame duck session, after the election, before the new Congress takes place. That's the plan, as far as we know right now. Whether that's successful, I have no idea. I didn't think we'd get a health care bill, I'm game to sort of wait and sort of see what's going to be there. So I think we'll have something in place. And I think that means that we will be able to promise that we can deliver on our 17% pledge. So that means the international negotiations will keep going. Now, where will we be on there a year from now? I think the international process basically has a year and however many months it is until the next big meeting in Cancun in December to sort of prove itself. I always like kidding my colleagues who work on domestic policy by saying, you guys think you have it rough with needing 60 votes out of 100 in the U.S. Senate. I need 192 votes out of 192 parties, right? Because the UN process, it's a process where every member has it's a consensus process. Every process has a veto. The only reason the Copenhagen Accord, as far as we know, was not an official agreement under the UNFCCC is because the ALBA countries, Nicaragua, Bolivia, Cuba, Venezuela, the anti-capitalist coalition of South American countries, used their veto to block it from going forward. Now that's really difficult. And I don't know if any kind of UN process is ever going to sort of get through the ALBA countries, but the hosts of the next big meeting in Mexico have supposedly forged a deal with them. So I think that where we will be, we'll be in the countdown towards whether or not we're going to try to get an agreement that works for the UN or abandon that process and try to do an agreement with just the largest emitters in the world, the largest developed and developing country emitters, about 17 parties, and see if we can get in a climate agreement that will get to stabilization that way. And I think that actually is probably a more optimistic solution.
Yeah, there's a lot there. I mean, one thing I should say about the waiting metaphor for this is that in some contexts that's okay, and let me say what I mean by that, is that from the standpoint of atmospheric stabilization, the analogy that people always use is of a bathtub. And because of the period of time that greenhouse gases stay in the atmosphere, if you really want to think about budgeting how much stuff we can put in the atmosphere, you don't want to think about it in terms of year-by-year terms. You want to think about it in terms of aggregate, just taking into account how long things last in the atmosphere, right? So it's like a bathtub with a drain, and at least right now a spigot that's putting water in a lot faster than the drain. What matters is whether or not you overflow the bathtub, whether you do that by waiting till the last minute and shutting the water off completely, or slowing it down a little bit. Well, that's, you can do it either way. And so, and the NAS in their America's Energy Choices report talks about thinking about this in terms of a total budget. So in that regard, if waiting means not doing a lot of small things now, but doing much larger things later, then that might be okay. It obviously depends on what those things are. In terms of where I'd like to see us go, I don't think there will be a climate bill, and I think trying to do something to reconcile with Waxman-Markey is a disaster, and I think it would be very unfortunate if the legacy of the BP oil spill is to enact the sort of corporate welfare-laden cap and trade legislation that companies like BP were behind and actively supporting. A cap and trade bill is essentially a tax bill with corporate welfare tacked on. If we're going to price carbon, let's just price it directly. And my hope is, and in my more optimistic days, I think that the mood of the country is moving in this direction, is that people are willing to talk about things that price carbon and things that deal with greenhouse gases, but they want them clear, transparent, simple, and direct, and not these gargantuan Byzantine Ponzi schemes of the sort that we see in the Waxman-Markey bill. Not the sorts of things that Enron for years was trying to get set up so it could game them, and that was its big thing before it went belly up, and it was one of BP's big strategies. They spent more time working on that sort of thing, apparently, than they did on the safety of their actual operations. And what would satisfy those sorts of requirements? Well, something like James Hansen has proposed, which is essentially taxing carbon directly and then fully rebating it on a per capita basis. So you essentially say to everybody, if you use a lot of energy, you'll be a net payer into the system. If you reduce your energy use, you won't. It's transparent, it's simple, it doesn't have the economic distortions and costs of a lot of the other alternatives. No one has to see an approach like that and say, gosh, who's secretly getting rich by this? Who actually got permits handed out to them? Who's gaming the system? It's simple, it's direct, and it does the job because in the clearest and most transparent way, it puts a price on carbon, which is one of the things we need to do. The other thing we really need to do, and again, I like to think that there's some push for this, and the Obama administration has actually quietly, in my views too quietly, been making some moves in these directions, is recognizing that to get the sort of innovation we need to move beyond the traditional R&D subsidy approach to technology and to use other sorts of tools like, for example, prizes and contests. There was an OMB circular back in March with very little fanfare that the Obama administration issued, pointing out, I hope correctly, and I think correctly, that agencies under existing statutory authority have far more ability to use prizes and contests and other sorts of other ways of leveraging federal investment in research and development and technological innovation than they're currently using, and encouraging them to do so. Because up till now, With the exception of DARPA, very few federal agencies spend much time using contests and prizes. But that's the sort of outside of the box thinking we're going to need if we're actually going to get the sort of innovation we need. Because last point, the way we're going to get an international agreement is when we can say to other countries, we want you to go along with us, and it's not going to cost you a lot. And until we reach that point, I think we'll keep having these near misses like the Copenhagen Accord. And the faster we get to that point, the sooner we'd actually have something significant.
Thank you. Now we have some time for questions and comments, observations from all of you. I think there is a microphone, so if you want to raise your hand, the mic can be delivered to you. It looks like it is.
Hi, thank you very much. The UN has published 2 reports providing substantial evidence that raising meat for human consumption contributes at least as much, if not more, to global warming than all the cars and trucks in the world. And is this on? Can you hear me? Okay. And also the Pew Charitable Trust also came up with a similar report for the United States. And I haven't seen any publicity. I haven't seen anybody talk. I haven't heard anybody talk about this. And it seems to me that we can do something here in the United States without having to wait for the entire world in order for us to exhale. Do you feel that this is an important issue? And what is the government doing to address the issue, or what should the government be doing to address the issue? And by the way, this has been attributed a lot to the CAFOs, concentrated feeding lots, and the immense amount of nitrous oxide and methane that's released into the atmosphere because of these agricultural practices.
Well, it's too bad we don't have somebody here from USDA, and I'm a vegetarian. Okay. I mean, that's a very complicated issue, and I think touches on a lot of other policy questions about production of food. But certainly, I've seen those same kind of statistics, and I think a lot can be improved upon in terms of our food production in this country, and hopefully USDA is taking a good look at that issue. But I think that would be the primary, aside from the CAFO issue, which is obviously an EPA issue, along with USDA and the states. I think it goes to, in large part, to a question of food production policy. But I think a good point.
I just have an observation about how interesting, even in your own question, you reframed the problem twice. So, and I think that's true of a lot of the climate challenge. And I think it may be an opportunity, which is that you said first the problem was meat consumption, and then the problem became, which was so that one could target consumers, consumer choices and so forth. And then another problem is the emissions themselves from the facilities that produce the meat. And that you could have a different response to a more conventional regulatory response. And I think that in thinking about climate change, we need to be aware that the way we frame, obviously the way we frame the problem is going to affect the way we frame the solution. And if we frame the problem too narrowly, we might miss sort of non-obvious ways of attacking the problem.
Somewhat related to that, just note, we always talk about carbon dioxide, and I think we were all as guilty of this as everyone, but it's not the only greenhouse gas. And there are an increasing number of folks, I know Robert Watson, who was former head of the IPCC, Stacey Jackson at Berkeley, and some others who pointed out that not only are there different gases, but they have different greenhouse forcing. How powerful each molecule of the different gases varies, and how long they stay in the atmosphere varies. And there are a lot of folks who argue that, especially in the near term, it makes a lot of sense to be focusing on methane as well as black carbon and some other forms of pollutants, and that when we throw everything into the carbon dioxide box, we actually make part of the problem more difficult because there are some things we can do in the short run that don't involve focusing on carbon dioxide. And certainly both agriculture and livestock are certainly significant contributors to methane.
In California, there is likely to be a ballot measure this fall to suspend AB 32 until there is more than a 50% decline in the unemployment rate, which in California is very high. To what extent do you see the current legislation being imperiled by the unemployment and the economic problems we have in the country these days?
Yeah, I'm familiar with that challenge, and in fact, I think the language says that they have to go back to a certain percentage of 5%, and I think the last time it was like that was somewhere in the 70s in terms of the very low percentage of unemployment for consecutive quarters. And obviously, it's playing a role in terms of the debate right now with the recession. I wasn't able, because I was facilitating this dialogue in Delaware, so I wasn't able to watch the president's speech on the oil spill. And on the one hand, I heard that he did use it as an opportunity to talk about the need for an energy bill. On the other hand, to Jonathan's point about transparency and that people are willing to pay for something, I'm not really sure that politicians, including the president, who I think really wants an energy bill, is really willing to engage as much on this point because of the situation with the midterms and the fear that raising taxes in a recession is just going to be lethal. And so, I do really worry about that because, let's face it, I mean, cap and trade or, this linked fee that they have on the fuels, I mean, it does send a price signal. And that has to, in fact, be part of the solution because as much as I would like to feel like there's some breakthrough technology out there, Larry Goulder has done some work on this at Stanford that says if you're actually trying to incentivize technology changes, you're going to have to spend 10 times more money than by having a price signal because that drives all kinds of changes in people's behavior. And we obviously don't have 10 times more to throw at this problem right now. So the price signal has to be part of it, but I just think it takes a lot of political courage in this environment, and especially when you do have a recession. I do think that maybe there's some kind of sweet spot that looks at something like the Cantwell-Collins bill that does have this dividend approach that somebody else mentioned here earlier, giving something back in a populist kind of way to the public, but then also telling a story about investing in alternatives so that we won't be either sending our money overseas to pay for foreign oil or polluting our shores, and investing in new fuels and technologies that are going to be cleaner in the future and green jobs and all that. But I think a piece of it might have to be a dividend, a piece of it might have to be explaining to people why, yes, there is this price, but it's important to then invest this money in alternatives. I would like to believe that people are ready to accept that information, but I think that the political powers that be and the people who actually run for elected office might be in a very different place.
The White House has long been operating under the assumption that you got to make this a jobs bill. Sometimes to the frustration of those of us who work in the science community, that's the only thing they want to sort of talk about. So. But if you look at sort of the analysis that was just released on Tuesday by the EPA of the Kerry Lieberman bill and combine that with the analysis that was done by Project Catalyst and also by the Peterson Institute for International Economics, I mean, you've got a plausible story there of job creation. And from that bill, just as you did with Waxman-Markey, not quite as good, and also very modest in terms of cost. And I think that will sort of satisfy some of those questions. What they finally come together and put together, I don't know what it'll look like, but it's going to have to be, it's going to have to answer that question of what does it do in terms of jobs creations. And just on this whole point about pricing and where the money should go, I mean, if you look at the European lessons, we're not going to get where we need to go in terms of carbon reduction if we just rely on the pricing the pricing mechanism, whatever it is, to do that job, especially if you return all the proceeds back to consumers. You have to have some reinvestment in some form back into the technology sector. It could be in prizes. It could be in like traditional sense. It has to be a big combination in order to drive those switch outs from the old dirty technologies to the new technologies. That's absolutely essential. Though you need the price signal in there to fund that mechanism, but without that mechanism itself, you never get there in terms of reductions.
How does environmental justice intersect with climate change and measures to address climate change? And if there's no significant intersection, why not?
It comes up a lot, I think. I mean, I work closely with the states, who are closer to the people, which is one of the fun things about working with the states. And so there, for example, the way it came up in this initiative this week is that after the agency heads had this summit on Tuesday, we stayed behind with their staffs from transportation, energy, and environment agencies in 11 states, plus the District of Columbia, to talk about how we were going to start moving forward with a work plan. And we wanted to establish criteria by which we would decide which projects, for example, to try to work on together. And one of the things that the states came up with was if there's any kind of negative implications in terms of environmental justice, then that's a criteria that would rule something out. I think we're not as sophisticated yet, but we're just start at the beginning of this in figuring out how to identify projects that have co-benefits. But I think, a lot of times it's traditional air quality, and a lot of times what you do for greenhouse gas purposes actually complements what you would want to do in terms of local particulate matter pollution or nitrous oxides pollution or more conventional pollutants as well. So I think there are some things that are really pretty complementary. Adaptation, which Rachel talked a lot about, is a big topic for people because the vulnerable populations, as we saw with Katrina, are more vulnerable than the rest of the people, often in terms of just where they are to begin with, but certainly in terms of being able to be resilient because they have the resources and, a second house or, they don't, to move to. And so I think that EJ plays in a huge way on climate change, both domestically and certainly internationally as well.
Yeah, absolutely. And in particular, with the Department of Interior, the Native American population is foremost in our environmental justice policy, but also anywhere where we have management responsibilities, we always look at environmental justice issues. And it's true that when we are looking at adaptation and resiliency, it can't just be about the natural resource, it has to be about the human resource, the cultural resource. So that's something we look at in everything we do. It's part of our analysis, absolutely.
One just other observation, another place where it comes up is in the context of trading. Because of the relationship between the greenhouse gases and other pollutants, that often they come together. The worry is that with the trading program for, say, carbon dioxide, we'll say, well, it doesn't matter where the pollution ends up in a trading program because it's a global pollutant. But if you think of the pollutants that come along with it, they all have local effects, and so people worry about the distributional effects of a trading program from that respect. And I'll say in that regard, I think recent activities on the part of EPA, science-based activities, have complicated the picture to some extent because with what we're finding with the criteria pollutants, when our most recent air quality standards have concluded, is that the effects are more and more short-term, and that makes our analysis more and more local. So at the same time we've gone way global with the greenhouse gases, our analysis and our standards for the conventional pollutants has become more and more focused, and that I think makes more pointed the environmental justice concerns with respect to trading. And then there's another gentleman in the back who looks like he did.
That actually-
Also like, yeah, after you. Yeah.
That actually raises another interesting point, which is the related issue of carbon offsets in any sort of trading regime, which could also exacerbate any co-pollutant effects in EJ communities. And so I guess I'm just wondering what sort of something we haven't talked about yet, so I'm wondering what people think about the use of carbon offsets, both in terms of any distributive effects they may have, but also if that's the right way to incentivize people and businesses to take sort of positive climate actions.
Well, Jonathan's obviously dubious about them. Maybe
I'm
you
happy.
should
I mean,
start.
I think you can't, as a practical political matter, you can't have a cap and trade system without lots of offsets. And as a practical matter, it is very unrealistic to have a robust offset system that's comprehensive, that is reliable and verifiable, and not drastically manipulated by interest group pressure, which is one of the reasons why I think that while economists like to say cap and trade and a tax are theoretically the same thing, in actual practice and implementation they are radically different. And as I think the negotiations over Waxman-Markey showed, once you start saying, okay, we're going to have offsets, let's figure out what they should look like and who should verify them and who should measure them and so on, and who should, and what sorts of things we're going to try and verify and what things we're just going to cross our fingers about, you end up with a system that in practice isn't going to do what you want it to do. So which is why I think you bypass a lot of that and you do something that is achieving the same purpose, but is far more simple and doesn't require all those complications. And I also, in terms of, would argue in terms of reconciling whatever we do globally, in practice, a tax regime with border adjustments is easier to, for a lot of the same reasons, to accommodate into the global trading system than a cap and trade system, especially if you don't have some broader international architecture already in place, which we don't. So that would be my view on that.
And the other side of it, though, is that there's certain kinds of offsets that are going to be, I think, or at least programs that for which offsets are the only feasible way of imagining they get funded that are absolutely essential. And forestry is probably the most important example of this. So deforestation right now is responsible for if you sort of add it all up, it's roughly equivalent. The emissions from deforestation is roughly equivalent to the entire global transportation sector. Every car, every truck, every moped, all of it, right, combined. So to get a handle on this problem, we've absolutely got to get there. And you get this sort of co-benefit with avoided deforestation and reforestation, which is obviously sort of maximizing your potential biological sequestration. And so this is totally critical. It is so important. I mean, if you just sort of think about it, the numbers in terms of where we are with the commitments on the Copenhagen Accord now and where we need to be is roughly we're shy 5 gigatons of carbon. The forestry provisions in Waxman-Markey alone would take care of almost an entire gigaton of that, right? So it's a massive sort of sector. It's also it's comparatively a lot cheaper than things like CCS and stuff, which is not even proven. And so when we think about it, offsets are going to be sort of one of the ways in which you would really want to direct as much of that into the forestry sector as you possibly could to get that cheaper reduction. Now, it raises all these problems with monitoring and verification and all this kind of stuff, but I'd rather take on those problems, right, than sort of not have a mechanism that can actually fund those reductions.
And the cheaper means that it's hopefully then more politically feasible too. I mean, you know, I think you saw with the Cantwell-Collins bill, which is this, you know, cap and dividend approach, and the sponsors are more dubious about markets and offsets. But as a result, they took a more modest target. And so I think there is this trade-off. I mean, again, looking back at the experience of the states, you know, RGGI has just picked certain categories that they're comfortable with, that they're real, they're verifiable, they're measurable. And then one of the things that we do at our center, along with WRI and the Pew Center, is we help facilitate a dialogue among the 3 regions that are setting up these programs, and they're sharing information on offsets to make sure that they're all rigorous enough that if they would ever, say, join and link systems, if we don't get a federal bill, that everybody could feel comfortable that they're not just, you know, throwing away their credits on offsets that aren't real. But I mean, I think the questions of making sure that they're real and quality offsets are really important. But I do think that both from a political feasibility and a cost perspective, and from a, you actually get reductions in, you know, some of the non-CO2 gases that we talked about earlier. I think those are some compelling reasons. And let's face it, you know, part of why the ag sector, you know, isn't capped in the bill, and they have offsets that actually does try to give them something to, you know, be interested in, is that they're very, very powerful politically. And so, you know, finding ways to get some of these sectors to stop objecting to the bill and maybe be supportive would be helpful.
I would also just add that, you know, while offsets are a very important component of this problem, that I think we have to be careful if we end up using offsets in a context of resolution of environmental liability, because it'll be very difficult to scale the effect of the offset with the effect of the violation of law. And so that's just one sort of cautionary area, is the scaling issue is very hard to measure.
I came in late, and I apologize if the panel's already addressed this, but Ken Cuccinelli, who is the Virginia State Attorney General, has addressed
No.
has sued the EPA over what I believe on multiple grounds. One of them was federalism on the EPA's ability to regulate just certain climate change aspects. I was wondering if the panel could just address federalism issues as related to the EPA, if that's appropriate. understand the question.
Well, which law, I mean, there's one, he's involved in one of the endangerment lawsuits, and then he's got a,
He's got 2 lawsuits, I believe, right?
One is going after Mike Mann, too, the climate
Right.
scientist. He's very busy.
He's a very busy man.
As a
yes.
taxpayer of Virginia, I'm not sure he's busy doing what he should be doing with
I'm
my
a taxpayer
money,
of
but he's
Virginia as
very
well.
busy.
But I'm referring to the one where he's directly suing EPA over their ability to regulate
Under the
emissions,
Cleaner
I
Act, so it's the
Yes,
endangerment.
that one. So.
if it's the endangerment suit, and there are a bunch of folks that have filed suits challenging the endangerment finding, which is the initial threshold finding EPA made that emissions of greenhouse gases cause or contribute to pollution that can be reasonably anticipated to endanger health or welfare. It's more or less the test. That unless someone finds some really big mistake, procedural mistake EPA made, which I think is unlikely, those suits will all fail. And they will all fail because the threshold that EPA has to meet is actually quite low. You know, it's not a preponderance of evidence. It's not a prove the world's going to end. It's not a prove. It's show that the administrator could reasonably anticipate that greenhouse gases cause or contribute to pollution that can have adverse effects on people, or welfare is defined to include pretty much everything under the sun. So that should be relatively easy to defend by EPA. Now, I mean, there are plenty of examples of agencies forgetting that they still have to dot every I and cross every T, and I suppose it's possible that one of the endangerment challenges could sneak through on that ground, but I would think it would be very unlikely, and I suspect that most of those filing the suits realize that.
We do have a tremendous number of lawsuits that we're facing. Everyone, when EPA does something, everyone sues, right? So, I'll stop there. I think we have time for one more question, and then, if you want to approach us afterwards and talk about some of these issues, we're happy to do that.
I'll share a fact, and you can decide if there's a question in it. Jamie Studley from Public Advocates in California. Under the Attorney General heading in California, the Attorney General intervened in a housing and zoning matter, Urban Habitat versus the City of Pleasanton, on AB 32 grounds, adding to the heft of the housing and zoning work that we were doing, saying that the ability to locate housing for workers near where their jobs are reduces travel time. The cost of housing drives people far out and puts them on the road for a lot longer. And their intervention on the climate change issues really helped get attention and expanded the universe of people who would understand the implications and be supportive of this matter. They came in usefully after the case had been pending for a while, but there's a lot of hope that they will be able to do climate justice work and at the same time ratchet up the salience of some other issues and bring them all together the way they ought to be working with us on housing and transit. So a ray of hope as well. Maybe in a year we can report some additional results.
Why don't we conclude with a ray of hope then?
That's good.
Thank you so much for coming.